I'd first like to give you a short introduction to our speaker, Joshua Rozenberg. Joshua Rozenberg has the honour of being the first journalist to have ever been taken seriously at QC, honorary QC, which is unprecedented in terms of journalists and law in the UK. Joshua, as you know from the biography, has been a reporter and presenter for BBC, and he continues to write as a legal affairs commentator for many other outlets, and also has his own outlet, which is joshuarozenberg.net. Joshua has a huge amount of experience of taking stories and data that appears in court. Joshua is hosted by Mark Beale today, he's the Registrar of the DIFC Courts, and David Gallo is the Director of the Academy of Law. As he's saying that the purpose of today is to look at how you take what happens in the courts and is made public, and to use that as the basis of hopefully great stories, which you will then be able to pursue as business journalists.
I have been covering legal affairs for about 30 years, first of all for the BBC, then for the Daily Telegraph, now as a freelance, and I'm very happy to tell you how I cover courts, because where I come from, the courts are opening up. The family courts are being opened to the press, and what is called the Court of Protection, which is a court that deals with people suffering from mental disabilities, that's being open to the media. So there is an openness in England and Wales that you don't necessarily see in other parts of the United Kingdom. As I would normally do, the lawyers on each side, if I could have a copy of their skeleton arguments in advance of the hearing. The skeleton arguments are a summary of the arguments which are put to a court in writing in advance, so that the court has the background and so that it's not necessary for the lawyers to explain everything in detail. Because this was an appeal court, there wasn't going to be any oral evidence, this was simply going to be questions of law. And I had a lot of trouble getting hold of these written arguments from the parties. Eventually, just as the hearing was beginning, they both emailed me their written arguments. They were concerned that it would upset the court if I had copies of their arguments before the hearing. I don't think it would upset the court. My view was these are public documents and we were entitled to see them as reporters. But nevertheless, I did get them. It all then went a bit wrong because the hearing didn't quite get going. There was an objection from the Attorney General of Northern Ireland, who argued that the law under which the hearing was taking place didn't actually apply. And the consequence of that was that the arguments have been postponed and they still haven't been heard. But I've got the skeleton arguments. But in England and Wales, it's absolutely fundamental that you ask the lawyers for copies of their arguments. They're not always prepared and they say, I'll email it to you or I'll give it to you tomorrow or whatever it is. But there have been times when I have said to the lawyers, when they've refused, look, these are public documents in England and Wales. Do you want me to make an application to the judge at the beginning of the hearing to get hold of these documents because I'm perfectly prepared to do so? And they usually say, oh, well, if the court says it's all right. And I then, on a recent occasion, sent a message to the judge saying, look, I am going to make an application to the court to get hold of these documents unless you come into court and say it's okay. The message came back from the judge via the court clerk to the lawyers to say it was perfectly all right to release these documents to the press. And so we got them, and there was no need for me to make a formal application to the judge. I said to the court clerk, look, if I'm going to report this case, I need to see the basis of it. I need to see the written documents that you, the court, have got. And as I say, we, the journalists in London, are quite happy to stand up and make an application to the court for these documents. And in a moment I'll ask Mark what the situation here is at the DIFC court and what circumstances the pleadings, as the lawyers refer to them, the written arguments are public and at what point they're available to the media, how journalists can get hold of them. Because if you go into a hearing and if there have been written arguments provided by both sides, then the chances are, after about a minute, you will have lost any understanding of the case. You will not have been able to understand what the case is about, because everybody, the lawyers on both sides and the court, will be referring to written documents which you haven't seen. And if you haven't seen those documents, you're never going to be able to report the case. Now, so far I've been talking about appeals which don't have witnesses. Obviously, it's easier at a trial, and the trial for this purpose includes a civil claim, if you have witnesses giving evidence, and the witnesses may well have interesting things to say from the witness box. So the message I've got for you so far is this. There are two sources of information, obviously, in any court case. One, and I speak generically, is the lawyers on all sides, 2 sides, 3 sides, maybe more, and the other is the court itself. The first place to start, because it's probably the easiest, is the lawyers on each side. The first thing you can say to the lawyers on each side is, what is this case about? Can you send me your written arguments, your skeleton arguments, summary of your case, a claim form, any of the legal documents concerned? The second thing is, can you send me any of the written statements that are being made, copies of your evidence, and so on and so forth? The natural reaction of lawyers will be to say no. They will be to say, well, look, you might show this to the other side, to which you say, but the other side have seen it already, because you will have exchanged documents. Or, we haven't quite finished it, and we won't finish it until the day before the case, to which you say, fine, the day before the case is all right, provided it's, before the case. Or this may offend the court, and you say, well, why would it offend the court? These are public documents. You might report what we're saying before the case opens, and you say, well, I promise not to report what you're saying before the case opens unless you allow me to do that. So these are ways in which you can get hold of documents. Now, obviously, a written statement from a witness may tell you something of great importance, of great interest. You need to know the basis on which you're being given this document. Are you being given it for use not before the beginning of the hearing, as would be perhaps proper? Are you being given it because the lawyer on one side wishes to get an advantage in litigation and wishes you to report what that witness is saying before the hearing begins, because that witness sees some advantage in doing this? You need to be very sure on what basis you've got this document. Now, I just want to bring Mark in at this point and just ask about the practicalities of covering cases in the DIFC courts and the circumstances in which you as journalists would get these documents. I mean, what happens? Do you provide stuff in advance or what?
So, as the cases progress, the documents are publicly available on the website. The statements of case, the claim form, particulars of claim, defence. So what we would call the statements of case, which give you a flavour of the case, they're available on the website when the case goes live. And the case goes live when both sides have put in, say you've got a balance, when the claim and the defence are in, the case is live on the website and the public can access it. Documents which aren't statements of case, and that would include witness statements, which is the written evidence from the witness of their point of view about the case. They're not public documents on the website, so to get them, one needs to make an application. If the application is made before the hearing, then it would be filed in the normal way. It would go to both parties, they would have the ability to raise objections, and then there would be the right for the judge to call a hearing on that application, and there's a fee for filing an application. If the application is made during a hearing, say at the commencement of the hearing, there's no fee, and it will be determined by the judge ordinarily at that point. So we have had situations, Joshua, where journalists will stand up and say to the judge, I would like to make an oral application to see the document that is being discussed at the moment in order for me to better understand what's happening in this public hearing. And so those applications have been made, there's no cost, and if the judge awards it, then the court will give you the document at that point. Subsequent to the hearing, documents that have been referred to in the hearing including witness statements where the witness says, my evidence is as set out in my witness statement, become public because they've been referred to in the court proceeding. So, as a matter of public record, although no one's ever asked us for it, I don't see why somebody wouldn't be able to say afterwards, just as they can view the hearing on the court's website, I don't see why they wouldn't be able to say this is document in the public domain, please may I have a copy of it?
Yeah, go ahead.
Yeah, I'm interested in that demarcation between a public document in the course of a live hearing where the document has become a public document because it's been submitted, as opposed to the witness statement that hasn't been submitted yet. It hasn't gotten that far. How do the courts, I guess in the UK, what's kind of the conceptual discussion around, well, what if that witness statement never does get filed because the parties settle, or there's just a shift in strategic direction and it does not ultimately become a public doc, but yet it has been shared already? Maybe it's just more of a esoteric distinction than real, but
I don't think there's a simple answer, and I think it does depend on which country you're in, which jurisdiction you're in. The only advice I can give you as journalists is to make very, very sure when you get a document, the basis on which you've got it. If the document is given to you on the basis you can use it straight away, then you can do so, provided you do not fall foul of the law. There are two ways in which you can fall foul of the law. The first I've mentioned, and that's defamation, libel, and the general approach I've always taken is that judges are not going to be influenced by what they see and read in the media, but their policy is that they're lofty and aloof and not going to be worried by what you say. It's quite true, as Mark says, that if you were to run a campaign saying that one side in a piece of litigation is right and the other side is dishonest, that might be disrespectful to the court. But courts have to be fairly robust. With many of these things, those of you who are working for large media organizations, you have legal departments. You will take legal advice. There are in-house lawyers who can hold your hand and tell you what's okay and what's not. It's an interesting question, and it's a perfectly fair question. And it is a cross-jurisdictional problem. And it may be not a bad idea, as a matter of principle, for a media organisation to take legal advice. But let's talk about it from first principles. As Mark says, in London, anything that's said in court can be reported. Provided it's a fair and accurate and contemporaneous report, you can make it. And I'm sure that applies across the United Kingdom and further afield. And that means that you can't be sued for libel, you can't be done for defamation. That's the first point. And that the immunity to a libel suit under English law would apply, generally speaking, if you are reporting what is said in a foreign court, as I understand it. In other words, the courts will, on the whole, tend to, give some sort of protection. But I mean, the only honest answer to your question, are you going to get into trouble here by reporting what is said in the courts here, is, well, you certainly shouldn't. And I would have thought that the DIFC court would take a pretty dim view of the local courts here, or another UAE court, or any other court, subjecting you to legal proceedings for giving a fair and accurate and contemporaneous report of what is said in this court. I would have thought you could rely on the courts here to protect you. But you know, I can't give you legal advice, and it's something that maybe needs thinking about. But, you know, in principle, you should try it. And it would be pretty scandalous if, by reporting something in an open court, you got into trouble. As I say, that led to me leaving the Daily Telegraph. It was a long and tortuous period. But it was wrong. And I spoke to a judge of the court the next day, and they said, your analysis inside the paper was fine, but the headline, or the intro, which said, could get compensation, was wrong. And I couldn't tolerate that, and that's when I left. So journalists try and stretch things. And it's inevitable that they think about what a judgment could lead to. We all do. We look at this and we think, well, that's a very interesting development. I wonder if most people, you know, lawyers think where it's going to go. But the trouble is that if you've only got a few journalists in a room and they're all looking at the same judgment, and in England it's a press association news agency, and if the PA say, well, this could lead to this, this and this and so on, everybody follows that line and a slightly misleading picture can get out. So from the court's point of view, it's not a bad idea if there is somebody with some seniority who can talk off the record to the journalist and say, look, this is what the court has decided, but we are not saying the following, the following, the following. It's up to you to report what you like, we can't stop you, but think carefully, because it doesn't follow that just because we're saying A, that B is going to follow. So that's the advantage of a briefing. It's very difficult because a court is a court, it gives a judgment, it doesn't give interviews about its judgments. The judgment speaks for itself, it can be overturned by another court, it can be criticised by another court, but the court, the judgment, the written judgment contains it, and that's it, and anybody else is speculating. But it doesn't do any harm to provide a certain amount of guidance for the media on what the judgment actually means and what it doesn't mean, or at the very least, well, if you're going to say that, it's on your own back, but we didn't say this in the judgment. Does that make sense to you, Mark?
I mean, we've done that for the more complex judgments. People often say, well, it's 140 pages, what does it mean? And that's quite a hard question to answer. That's why we introduce the summaries, because that is a distillation of the case into a summary. And we hope that that's helpful.
But don't rely on the summary, because it depends what sort of person has written the summary. Many years ago, there was a thing called the Scott Report into arms sales to Middle East, and the judge Richard Scott, who issued this report of a public inquiry, which was very embarrassing to the government at the time, made the dreadful mistake of giving the entire report to the government a week in advance of publication, and then not issuing a press release and having a press conference, but refusing to summarise the judgment, summarise the report. And the consequence was that we were all throwing questions desperately at this guy who was pretty fed up at the end of the day, and we said, well, could this mean this? And he said, well, right. And everyone had the headline, you know, it was the question, it could mean this and that and so on. So everything went wrong there. No press release, putting it out late in the afternoon. But the worst thing was to give it to the government a week in advance, because the government was able to provide endless press releases, endless summaries, all leaving out the crucial bits. And, you know, but the government would, because this was a report that was critical of the government, and you give it to the government, what's the government going to do? It's going to provide a press release, which is, you know, puts the government in the best light. So it's fine if a court prepares a judgment, because it's going to be authoritative and accurate, but it's not going to tell you as much as is in the judgment itself. So don't think you don't need to read the judgment, because, you know, however good the press release is, there may be some phrase, there may be some aspect of the judgment, maybe some comment from the judge, which gives you the top line of the story. Always read the judgment. And any other, you know, official document. Of course it takes time and you can't do it immediately, but there's always something buried there. Certainly government bills in the UK have always got some little thing that was not leaked in advance, because it's very common in the government doing things to leak the things it wants you to report, and then you don't notice the things it doesn't want you to report. I'm not saying that applies to court judgments, but it's an absolutely basic rule. I mean, certainly the UK Supreme Court, certainly the UK Supreme Court sends out an email of forthcoming judgments. They advertise them a week in advance. The lower courts are not as well organised, and there are many more cases, so you have to look at the website and you have to recognise a case. And that's why keeping in with lawyers is very useful, because they can tell you when things are coming up. The other obvious thing is you can see a judgment coming up. I'm talking about a reserve judgment which is given several weeks after the hearing. And if it's an appeal, you can look at what was decided in the lower court to see if that's interesting. You can see if there were any reports at the time of the hearing. You can see what was published beforehand. So, you can, with a bit of research, you can obviously find out whether the story is going to be of interest to you. There's a lot of digging that you need to do, and I come back to what I was saying earlier. If you want to get the stories, they're often there, but you have to push, you have to look, you have to try, you have to dig, and so on, and you have to be a little bit brave, quite honestly. You have to be quite confident in what you're doing, and you can. I mean, maybe there are, maybe there's somebody else in your line of business, and you're prepared to share a story with them, so there's strength in numbers. Maybe it's a question of getting your in-house lawyer on board. Maybe it's a question of seeing if the court will help you and tell you what's happening. I don't know quite what you have to do. But I do know that the more you push, the more you dig, the more you look, the more you're going to be able to get stories, because we all know what the definition of news is. News is something that someone somewhere doesn't want you to publish, and all the rest is advertising, isn't it?
I'd like to say thank you very much to Joshua. Talking about being in the right place at the right time, I believe that we have, in some sense. He's opened up, hopefully, our court records for your reporting, finding ways to do that together. So I'd like to thank you very much for helping that process go forward.
Okay, and I'm around for a few minutes if you want private words.
So Joshua is here. He's not going away. We've almost got him in a locket.